Okay, good morning again, everyone. We will now continue with the case Blyden versus the government, number 67 of 2019. And we have Attorney Manning and Attorney Clement for the government. Attorney Manning, are you ready?
Yes, Your Honor.
Okay, very well. If you can adjust your camera, so we can get your whole. Okay, here we go. Okay, you may proceed. As usual, we're going to give you 2 minutes uninterrupted, and then we will ask any questions.
May it please the court, I would like to reserve 5 minutes for rebuttal.
Very well. You may proceed.
Thank you very much. Johanna Manning on behalf of Darrell Blyden, the appellant. Justices, my client was deprived of his right to a fair trial insofar as he was deprived of his right to give all the evidence to the jury for their consideration. And he was deprived of that by his own trial lawyer. In this case, there's evidence that the firearm that was seized from my client on the night in question was not the firearm that was introduced to trial. To support that statement, the seizing officer gave an affidavit and an interview to my client's lawyer at the time prior to the trial, and the lawyer did not present the witness to the jury so that he can explain himself, nor did the lawyer attempt to introduce the exhibit pursuant to 14 Virgin Islands Code Section 19, which at the time would have allowed the introduction of said evidence. The issue was a lot worse than this, justices. In this case, there was a serial number that was attached to the firearm that was seized from my client. The undisputed evidence at the habeas hearing was that what we did is we subpoenaed that record. We put that record on the evidence. That record did not have 2 serial numbers on there. We also subpoenaed the firearms manufacturer that proved in an affidavit on the business record that the firearm that Taurus firearm only has 1 serial number. At the trial, the chain of custody record, the police report, had 2 serial numbers, which demonstrates that someone outside of the police department added the 2nd serial number to the firearm so that the firearm could be admitted. And we submit that Mr. Blyden should have had a right to have all the evidence before the jury and let the jury decide what happened in this case. And that is not what happened. So we're asking the justices to overturn this verdict, let the jury decide it based on all the evidence so that he can have a fair trial. The fact that you have 2 serial numbers, the fact that Taurus International, the firearm manufacturer, it's all on the record, says that firearm only has 1, demonstrates that the only purpose of adding that 2nd serial number was so that this firearm, which was not the firearm that was seized, would be introduced at the trial. And when you look at the totality of the evidence, you've got 2 pieces of evidence that supposedly link my client to this case. You got a police officer that says that there was an excited utterance that was not recorded, and you've got this firearm. We submit that
just how would the affidavit have been admissible under Section 19?
Well, at the time, which was Title 14 VI Code Section 19 that was in place, the witness would have been put on the witness stand. If the witness refused to testify, then that section at the time would have applied, and we could have introduced it pursuant to the plain language of the statute at the time it was in place.
But doesn't it require that the statement be presented to him and he had an opportunity, and it would only be admissible if it was inconsistent with his testimony?
That's not my understanding, Chief Justice. My understanding of the statute at the time, and we had this come up in People versus John Williams. There was a long discourse where at the time the trial judge found that the exhibit could have been introduced even if the witness refused to testify. And they did that with the testimony in that case. So my position is there's still two issues, Chief Justice. Not the witness testified at the habeas hearing that had he been called, he would have testified. He was just never called. He testified under oath at the habeas hearing that I met with the lawyer. The lawyer never put me on a witness stand, but had she done so, I would have testified as to what happened. That's my recollection of the testimony at the habeas hearing. And that was Officer Dowdy, Joe Dowdy.
Wasn't this the third statement that he had made?
Go ahead.
Okay, go ahead, Judge Carroll, go ahead.
Yeah, no, wasn't Dowdy called as a witness, in fact, and didn't he refuse to testify?
He was called.
Why do you think it would have been any different if his attorney had called Dowdy as a witness? Dowdy refused to testify for the government. He was declared to be unavailable, and the only thing that was allowed into evidence was his testimony from the suppression hearing. Why do you think it would have been any different if Blyden's defense attorney had called Dowdy as a witness?
Justice Carroll, my understanding of the habeas record was that he testified, Mr. Dowdy, that had I been called, I would have testified. As to
that's hindsight, though. What about at the time of the trial? What indication would she have had that if he indeed was called as a witness, that he would have in fact testified on behalf of the defendant?
My recollection is there was that Dowdy testified at our habeas hearing that he met with counsel, trial counsel, and he made the representations of trial counsel. He also gave the written affidavit to trial counsel. He was cooperating with the defense. He was not cooperating with the prosecution, which I think he has a right to do. So the sheer fact that he would draft an affidavit, which was subject to the penalty of perjury, and submit that to Mr. Blyden's counsel, to us, tells us that he's cooperating with the defendant. And based on that level of cooperation, we would suggest that the very next step is to put the substance of the affidavit either through the witness and let the witness say he doesn't want to testify or cooperate, or attempt some.
What version would he have given had he testified? We don't know that, but that must have been a consideration that trial counsel had, because Dowdy had provided different versions of the facts regarding the authentication of the weapon, regarding the serial number of the weapon, regarding the weapon itself, actually. So don't you, well, you're arguing that this was not a part of trial counsel's strategy, I take it.
Correct. That's our.
Okay. Well, let me ask you this. Regarding the standard that Mr. Blyden had at the habeas hearing, he had to overcome the presumption that the decisions made by his counsel were not professional judgments, but he failed to call his counsel. So how did he overcome that presumption on this record?
It's our position, Justice Cabret, that he overcame that based on the conversations that his counsel had with the witness. So we have used the substance of those conversations to give it to the record. Now, I understand that the court may say, well, wait a minute, we have to presume, there could be a presumption that, you know, this was some kind of trial tactic or trial strategy not to put this evidence on the record. Our position is that there can be no tactic that deprives the jury of exculpatory evidence. And I understand that there were multiple versions, but it was the witness told the record what he was going to testify to, and depriving the jury of that, in our opinion, is of the level of ineffective assistance of counsel that doesn't require that the prior trial counsel tried to explain why she did not call that witness to the witness stand. I mean, that.
But if she was never called as a witness to be able to testify as to her trial strategy, how could Mr. Blyden have met his burden of showing that it wasn't effective?
Chief Justice.
Didn't counsel also cross-examine Corporal Bedminster about the differences in the serial numbers, and wasn't that issue flatly before the jury?
Chief Justice, two surgeons can always disagree as to how sharp a scalpel should be when you operate. I agree that she broached the subject, she introduced the subject, but clearly she didn't walk all the way down the road that would have been required in this case, because it would have gone to whether or not this firearm, we would have gone to authenticity, number one, and then it would have gone to credibility, number two, but she did. You
don't think that she had the right to determine the effect of calling a witness who was obviously perjuring himself, because he has made, 3 different statements. He was facing a first-degree murder charge and was in prison, and you don't think that counsel should consider what the jury would think of that, and whether or not she was in fact putting on perjured testimony?
Chief Justice, there was no alternative in this case. And our position, I mean, if we're at a crossroad and you can go right or you can go left, then I can understand that there is a decision to be made there. But in this case, we're submitting that the person who sees the firearm has told the trial counsel that I want to tell the jury what I just put in the affidavit. And on 3 occasions, he was consistent in what he said in that affidavit. We agree that, at the prior hearing, I guess it was a suppression hearing, he did state that this was a firearm he seized, but on 3 other occasions, he came out and was consistent with what he told trial counsel at the time.
But didn't he say he could not remember anything about the firearm that he seized? And all of a sudden now he's going to come and testify that he fully remembers everything?
Well, and Chief Justice, it's not uncommon for a witness to forget something, and then if he remembers it, then it's a jury question, Chief Justice. This is for the jury. All we're asking for is that the jury be given an opportunity to measure this case, and that lawyers not be able to preclude the jury from having all the evidence for whatever reasons they want. I mean, in this case, there was no alternative. You got 2 pieces of evidence. You got a firearm that had questionable whereabouts, and then you also had a excited utterance. Other than that, there's no other evidence that links Mr. Blyden to this case. This is not the kind of case where you had overwhelming evidence and nothing was going to be able to change the mind of the jury. This is a case that was squarely based on the credibility.
And the direct appeal in this court found that there was overwhelming evidence?
Chief Justice, that was based on the evidence that the court had, which was those 2 pieces. The firearm, which would show that this is overwhelming evidence.
Did the evidence change?
Yeah, absolutely. I mean, the evidence never actually changed, but the view of the evidence changed because the underlying basis of the firearm has been in question, but you never saw it on direct appeal because it was never on the record. Had that been on the record, we believe that the Supreme Court would not have found that the evidence was overwhelming.
Okay, thank you.
Excuse me, Attorney Manning.
Yes.
Looking at the police reports, they're very difficult to read. But what I was able to read from them was that the police reports were consistent that it was a revolver that was missing. If Dowdy had taken a stand, as you say, or whether if his affidavit had been introduced, it was clear that Dowdy was in fact contradicting that, because he said that it was a semi-automatic. So wouldn't that have presented a problem also for counsel if that affidavit had been introduced, that Dowdy's testimony would have in fact contradicted the police reports? I mean, forget about the discrepancy in the serial numbers, but the the police reports were very clear that it was a tourist 38 caliber that had gone missing back in 2003.
We submit that it's our view that that would not have presented an issue for trial counsel. Actually, that would have presented reasonable doubt for the jury.
Why would that have been beneficial to have Dowdy's testimony, or rather his affidavit, contradict the police reports that you had introduced into evidence?
Well, that would have questioned what specifically was seized. I mean, that chain of custody essentially said that from the time that my client was seized until the trial, this is it. The totality of his testimony was going to contradict that entire basis, and that's just our argument. I mean, it goes to the entire core, the entire basis of what they presented to the jury. The jury had no knowledge that there was a question mark as to whether or not what they have here is what was seized from my client, and that's all we're arguing. That's one of the main arguments that we're making.
Okay, thank you.
Thank you, Chief Justice.
Attorney Clement.
Morning, Your Honors. Assistant Attorney General Ian Clement on behalf of the government. Mr. Blyden wants the court to believe that there's this grand conspiracy to frame him for this particular case, but this court had already decided that the chain of custody in this case was sound and affirmed it on direct appeal. Is also affirmed by the Third Circuit. The fact of the matter is, when it comes to Mr. Dowdy's testimony, he refused to testify. He was voir dired by the court extensively as to his desire not to testify. He stated he didn't want to testify. He himself had been at that point was in custody on a murder charge, and he didn't say anything about wanting to testify for the defense instead of the prosecution. So there's nothing in the record at that point in time in which would give trial counsel confidence that she could put him on the stand and he would testify at that point in time on behalf of the defense. And so when you look at that, Mr. Blyden has not met the high standard to show that her level of counsel fell below a standard of reasonable soundness. So they fail on that point. The second point, and the habeas court pointed out that despite any discrepancies in the police report for the theft of the gun from the federal court, that doesn't thwart the chain of custody. It was shown that the bullets retrieved from the body of the victim matched the shell casings and the tool marks of the gun that was presented at trial. So to state, as Judge Carroll has stated, to bring in this affidavit to say it was a semi-automatic weapon, which, when we know, based upon the testing that was sent to the FBI, that we're dealing with a revolver. The police.
But how does the fact that the bullet in the victim matches the gun, how does that take away from the fact that there's nothing to connect him to the gun, if in fact that gun was the incorrect gun that was seized? There's no question that the gun that was introduced in evidence was the gun that killed the victim,
right?
Based on the bullet markings and everything else. But if there is a discrepancy that is not the gun that was seized from him on the night, how is he connected to it? Unless, I don't see the connect, there has to be something to connect him. And if in fact there is, testimony that gun that is identified as the murder weapon was not the gun that was seized from him that night, isn't there a disconnect
No, Your Honor, because you have to look at the testimony. Let's look at the testimony of former Detective Dowdy's partner on that night. She took that gun into custody. She took that gun. She got that gun from Dowdy. She started the chain of evidence. So there is a connection from the point of seizure into bringing that gun into the chain of evidence. So that was established. Now, because Dowdy has an axe to grind with the government because he has been convicted of murder himself, he wants to, I guess, throw a monkey wrench into this other prosecution. But that his testimony or his purported testimony was really not to be believed. And the trial counsel at that point in time had a duty under the rules of professional conduct. And Attorney Manning wants you to believe that she had no choice but to potentially violate the rules of professional conduct because she had reason to believe that former Detective Dowdy's testimony was not reliable, was not truthful. And as the habeas court noted, and at this point, he has changed his story as to whether or not it was a handgun, or he didn't remember, or it was or it was a different type of gun 4 times in the last 17 years. So based upon that, Your Honor, I would say the government submits that that her failure to introduce his affidavit was not unreasonable, and she did not fall below a standard of objectable reasonableness. And if the court has
what about his argument that the evidence was fabricated by the government, I guess?
Well, as the habeas court noted, they have not shown, despite this discrepancy on this police report, when that was done or by whom. And it was Mr. Blyden's burden to connect the dots, to show that the government fabricated this evidence, and that just did not happen. It did not meet their standard at habeas or even prior. So this court should not overrule or its prior holdings on appeal, on direct appeal, regarding the chain of custody, regarding the providence of that. And really, this entire thing goes to this serial number issue goes to the matter of authentication, which this court has already ruled upon, that because of the use of the prior uniform rules of evidence, that the authentication or lack thereof, that the chain of custody was sound in this particular case. If the court has no further questions, we will rely on our briefs.
Oh, well, Manning, reserve 5 minutes.
Yes, thank you very much. And we just wanted to address the 3 points that were brought up. Now, at the end of the day, based on the fact that Attorney Todd understood that there was a serial number issue, insofar as that there was the serial number that was on the police report did not match what was on the firearm. She understood that, and she brought that topic up very lightly to the jury. So she was aware there were issues with the firearm. So for her then
Attorney Manning.
Yes.
The question was asked, I think, earlier in your argument. I'm not sure whether it was actually answered by you. Why didn't you call Attorney Todman as a witness during the habeas corpus proceedings?
Justice,
he was clearly available to testify. So I'm just wondering, was there some reason you did not call her?
Justice, in our view, we didn't believe that we needed to. And the reason I say that is because it's clear on the record that she was aware that there were issues with that firearm, insofar as that serial number that's on the police report that she had did not match any serial numbers on that firearm. She was aware that the serial number at the police department didn't have 2 serial numbers.
And that was argued before the jury by Attorney Todman, wasn't it? That was that was brought, that evidence. As a matter of fact, she introduced the police report into evidence that had only one serial number on it.
Justice, and that's what proves that she believed that there were issues with that firearm.
But it was presented, excuse me, I'm sorry, but it was presented before the jury.
It was, and I'm just arguing that no argument could have been made by Attorney Todman that she didn't believe that there were issues with that firearm. The very next step to do, in our view, is to call a witness who she met with. Now, even though the witness may not have at the hearing stated that he had had these conversations with Attorney Todman, and even though he stated at the habeas trial that we talked and I was available to be her witness. That was his evidence. So because she believed that there were issues with that firearm, it's our view that no argument can be made that she didn't believe the evidence, so she had a duty as a lawyer not to put the rest of the evidence on. That's our position. I mean, at the end of the day, she believes that this is a valid issue. She has an absolute obligation to put the witness on the witness stand. He was there cooperating with her. If she didn't go over there
didn't she have knowledge that there was also issues with Dowdy's several statements, including his affidavit, and that she had to the judge whether or not it would benefit the client to call a perjured witness to the stand and have the jury realize that he was now relying on perjured testimony. And if that went into her thinking, don't you think you had an obligation to call her as a witness so that the judge could determine whether or not it was proper trial strategy? And in the absence of calling her to allow her to explain, how do we now go behind and say, well, she provided ineffective assistance of counsel by not introducing the affidavit?
Chief Justice, it's our view that, clearly the fact finder would determine which statement was perjured. The fact finder would determine whether or not the statement that he made, that this firearm is the one he seized, that's an issue for the jury, not the issue for the justices and not the issues for the habeas court. All I'm arguing is that evidence.
Oh, I'm sorry. Attorney Manning, are you saying that if a lawyer knows that the witness the lawyer may call is going to lie to the jury, the lawyer still has a duty to call that witness? Is that your argument, sir?
Justice Cabret, my argument is that lawyer wasn't there at the scene of the crime. She's got conflicting evidence. She can't decide which is the lie.
No, that's not my question. That's not my question. And my question was, when a lawyer knows that a witness is likely to lie under oath, let me ask you a little different. Does not the lawyer then have a duty not to call that witness?
It depends, Justice Cabret, it depends. If I've got 10 statements that I need to elicit from this witness, and I know the witness may lie about issue one, I will not ask that witness that question. I will ask the questions to the witness where I can't independently assess what the truth is. We cannot solely rely on Dowdy's testimony. How do we know which one was the lie? At the end of the day, she knows that there were issues with the firearm. She knows it. She had an opportunity to debrief this witness, and the witness wanted to come there to testify about it. We as lawyers do not have a right to make our own concrete, conclusive credibility discussion.
Did you cite that principle? Cite any law supporting the principle that you were arguing? That a lawyer has no choice but to put whatever to the jury?
Not that point in particular, but because
that's the point you're arguing, and that's what we have to look to. We have to look to the law.
Absolutely, but under the general umbrella that there was ineffective assistance of counsel, my argument is that witness, my global argument, my consistent argument is Attorney Todman is not the jury. She can't come out and say, I just don't believe that statement. And then all of a sudden, the jury is now deprived of material evidence that goes to the very nature and the very substance of this case. I mean, I agree that as lawyers, we cannot put on perjured testimony. We can't do it. I mean, we would have to come back individually before this court. However, she acknowledges that there were problems with the firearm, and the person that could explain it wanted to testify, and he was precluded from doing so. That's just our general argument. And there can be no arguments in our mind that she didn't believe that there were issues with the firearm. I mean, because she argued that to the jury. So that's our position, justices, and we ask for your consideration of this matter. And I'm available.
Okay.
For any questions.
Okay, thank you.
Thank you very
The
much.
matter will be submitted.
Thank
So thanks, everyone,
Thank you, Your Honor.
for this technically challenged hearing, but for all who didn't get a chance to view it, stream or recording will be posted shortly.
Very well.
Okay, thanks, everyone, and we are adjourned.
Okay, very well. And let's see, you said 1 o'clock, so I'll be back with you. at
Well, we
1
will probably, the first one will go on, so we'll probably like 1:20, you can join in.
Okay, well, I'll check back in at 1 o'clock.
Okay, good.
Thank you.